Non-fungible tokens, or NFTs, are all the rage. So naturally, cybersquatters are getting in on the action too, which means that trademark owners need to be on the lookout for a new type of problem, as Morgan Stanley just learned in the very first NFT-related domain name dispute decision. Hi, it's Doug Isenberg, and regardless of what you may know about or think of NFTs, there's no denying that they're having a big impact, at least right now in the spring of 2021. In fact, it's impossible to go a day without reading about some shocking new development in this area of technology meets art meets cryptocurrency. CNN said that NFTs are fueling a digital art boom. The New York Times and everyone else reported on a $69 million sale of a digital image at the heart of NFT mania. And the Wall Street Journal is trying to explain to its readership exactly what NFTs are. In short, NFTs, or non-fungible tokens, have been described as a type of digital asset that exists on the blockchain, the same tool used for tracking cryptocurrency, such as Bitcoin, which is essentially a public ledger that allows anyone to verify an asset's authenticity and ownership. Now, every NFT has a unique digital signature, meaning that it is one of a kind, sort of like an original work of art or a collectible playing card. But NFTs are digital, which is why electronic works, such as animations, photos, and audiovisual files, and even music, are among the more popular NFTs, though just about anything digital, from Jack Dorsey's first tweet to sports clips to a New York Times article, can qualify. And the sudden attention has created a tremendous market for NFTs, with copyright owners and collectors all cashing in on the craze. Which means that cybersquatters, who also never miss an opportunity to cash in, are doing the same. This should surprise no one after all, because cybersquatters often follow trends from pornography to politics to the pandemic, looking for domain names that may quickly become valuable. And that's what happened in the case I'm talking about here, which involved the domain name NFTmorganstanley.com, and appears to be the first NFT decision under the UDRP, the Uniform Domain Name Dispute Resolution Policy. The complaint in this case was filed, obviously, by Morgan Stanley, the financial services firm. Now, Morgan Stanley is a public company listed on the New York Stock Exchange and provides investment banking, securities, wealth management, and investment management services through offices in more than 41 countries. According to the UDRP decision, which was published by the Forum in May 2021, the firm has trademark rights in its name that date back to 1935. But in April 2021, someone registered the domain name NFTmorganstanley.com, which obviously contains the Morgan Stanley trademark. Now, Morgan Stanley wasted no time going after this domain name, filing its UDRP complaint just 1 week after the domain name was registered. The decision says that the domain name was used in connection with a website that had PPC, or pay-per-click links on it, which is an easy way for cybersquatters to generate revenue. This is what the website associated with the domain name looked like shortly after the UDRP decision was published. It's impossible to know whether the registrant of the domain name actively chose to have this PPC page or whether the registrar, GoDaddy, generated it by default. But it doesn't much matter, because UDRP panels generally say that a domain name registrant is responsible for the content on a website using the domain name, even if PPC links are automatically generated by the registrar. In any event, given the strength of the Morgan Stanley trademark, this wasn't a difficult decision for the UDRP panel, and the panel's analysis on the first element of the UDRP, whether the NFTmorganstanley.com domain name was confusingly similar to the Morgan Stanley trademark, was straightforward, short, and consistent with the UDRP consensus. Specifically, here's what the panel wrote. The domain name consists of the complainant's Morgan Stanley mark, which is registered inter alia in USA for financial services, with first use recorded as 1935. The acronym NFT, meaning non-fungible token, and the GTLD.com. The addition of a generic term in a GTLD does not negate confusing similarity between a domain name and a trademark contained within it. Accordingly, the panel holds that the addition of the term NFT and the GTLD.com to the complainant's mark does not prevent confusing similarity between the latter and the complainant's mark. Now, in the rest of its analysis, the UDRP panel found that the registrant of the NFT morganstanley.com domain name had no rights or legitimate interests in it, and that the domain name was registered and used in bad faith. So in the end, the panel, not surprisingly, ordered the domain name transferred to Morgan Stanley. Now, as I'm recording this video, there are at least 2 other UDRP decisions pending for domain names that contain NFT. ComericaNFT.com, which contains a trademark owned by a bank, and GeicoNFT.com, which contains a trademark owned by an insurance company. And I wouldn't be surprised to see many more, especially if trademark filings are any indication. In just a little over 2 months, more than 50 applications have been filed for trademarks that consist of or contain NFT in the United States alone. Another indication that anything with NFT in it is a potentially hot property. And while these first NFT domain name disputes under the UDRP all involve financial services companies, any and every trademark owner is potentially a target of this newest cybersquatting trend. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other UDRP cases. Thanks for watching, and see you next time online.